Greetings, my fellow Americans, and welcome to the Great Montana Conspiracy Podcast. Today I'm actually going to go and talk about a bit what I ended on the last podcast episode. And I actually had a little addendum to try to explain it, but I don't think I really got my point across. So I'm actually going to dedicate this episode to that, and we're going to talk about the Montana Bar Association. Specifically, what makes the Montana Bar Association such a critical element of the Great Montana Conspiracy. Okay, so first of all, the Montana Bar Association is modeled after the American Bar Association, or at least in principle, in theory, it is. The American Bar Association was established on August 21st, 1878. It was designed specifically with the core purpose being the advancement of the science of jurisprudence, the promotion of the administration of justice, and a uniformity of legislation throughout the country. That latter part, legislation throughout the country, indicates what the body really was. It was an advocacy for lawyers. It was a lobbyist organization for attorneys. The whole idea was to help regulate laws that benefited attorneys throughout the country. The ABA has had a massive history of problems. You see the American Bar Association, you think, oh, this is a great, upstanding organization. No. First of all, and to be clear, this is not a government agency. It is not attached to the government in any capacity. Okay? It has been a persistent and consistent advocate for attorneys. It has even been a lobbyist for attorneys on many, many occasions throughout the country, around in states, federal constitution, or federal legislations, etc. They are lobbyists, first and foremost. Although they're supposed to exist for the purpose of helping to regulate the standards of law through law schools and to set model ethics for attorneys across the country. What they actually are doing is actually defending attorneys and actually organizing attorneys into a personal cabal for the purpose of perpetuating their industry, which is the practice of law. They've helped form laws which have favored practitioners over private citizens ever since. They have formed their own. The states have formed their own. Every state has formed its own variation of a bar association. Most states require their attorneys to actually be members of the state bar association. Only roughly, I guess, like 50 or 60% of the attorneys across the country are part of the American Bar Association. But states usually regulate and require their attorneys to be members of the state bars. At least the ones that are integrated in some capacity with regulations. Again, in practice. In Montana, you must be a member of the bar to practice here. No ifs, ands, or buts about it. You must be. And this is because Montana Bar Association is what's called an integrated bar association. Now, you may think integrated means, oh, they're part of government. They're not, really. They were formed at the order of the Supreme Court, but they aren't actually overseen, regulated, controlled in any manner, shape, or form on an active basis by the Supreme Court. The Supreme Court just basically ordered it, and I will get to the reason for that in a few minutes. But since they are not formed since the American Bar Association was not formed by a government, it's been maintained as what's called a self-regulatory agency to avoid government oversight. No, it wasn't formed for that purpose. It was formed to be a lobbyist group. It says it right in its foundation and its principal constitution, to create a uniformity of legislation throughout the country. And by the way, that statement was a quote directly from their first constitution. The advancement of the science of jurisprudence, the promotion of the administration of justice, and a uniformity of legislation throughout the country is a direct quote from their first constitution. From day one, they were there to influence legislation, and that is a lobbyist organization, ladies and gentlemen. Okay, make no mistake, that's what they were there for. They shelter attorneys from oversight. They change laws to make more favorable. They outlaw anyone practicing law who is not an attorney. Keep in mind, that was not always the case. In fact, by the ABA's own admission, prior to 1878, there was no actively organized legal profession. They were attorneys, and there were people who were trained under those attorneys as apprentices, just like in any other trade. Just like if you were an importer exporter, you'd have apprentices working under you. The same concept worked for attorneys. There was no standard, there was no anything. And although the American Bar Association itself is not necessarily corrupt, their the way they've structured themselves permits for the existence of corruption and lacks any real capacity to control it. Once again, we're right back to the foxes being put in charge of the henhouse. The foxes are eating the chickens, so let's ask the foxes to self-regulate themselves to not eat the chickens. It doesn't make any sense, but government oversight was a big issue. In fact, the United States comic books adopted what was called the Comics Code Authority in 1954. The Comics Magazine Association of America put this organization together because there was a great push by government to regulate the content of comic books. They were horror books, there were crime books, the concern was that violence and all this gore and everything else that appeared in comics far less than what exists by today's standards in media, but just the perceptions of the 1950s. It was that this was going to somehow corrupt the youth. And so to avoid government regulations, the comics themselves, the Comics Magazines Association of America, helped form the Comics Code Authority. Like the ABA, it was self-regulatory. The idea being they were in charge themselves of their own regulations. The government didn't come in and set those regulations. The government didn't step down and say, okay, you need to follow these guidelines and then let them go. No, they were completely self-regulated. This is what the American Bar Association became, even if it wasn't its initial function. It became a self-regulatory agency to avoid government oversight. Once this organization helped create the legal profession, and they most definitely helped create it, there was a great concern that the creation of this unified force was somehow going to become a force to be contended with. Therefore, they became a self-regulatory agency, and they started adopting ethics for their attorneys, ethical codes of conduct. Now, every state has adopted a version. Now, keep in mind, once again, the state bar associations are not affiliated with the American Bar Association. They are separate, they are independent, they are modeled after, but they are not subdivisions of the greater whole. These are not chapters of a larger organization that exists out there. The American Bar Association exists as an example, and it encourages state bars to adopt their methods. But they don't have to. They can adopt what they like, they can modify it, they can do whatever they want. As an example, in Montana's Code of Ethics for Attorneys, there's actually a standard in the American Bar Association's version that requires a certain number of hours to be dedicated to pro bono work, which is in benefit of the community, in benefit of the poor, in benefit of somebody who's in need who can't afford the legal services. It's just a suggestion in Montana. They recommend it. It's not mandatory. It's recommended. Major alteration there because now attorneys don't have to do anything they don't want to do. But in principle, self-regulation is so that industries can swear to uphold certain standards and thereby avoid the need for government oversight and regulation. So the idea being that if I'm running a t-shirt factory and I'm concerned that the government's going to come in and regulate how I make my t-shirts, I will get together with other t-shirt companies and say, hey, let's make an industry agreement and a pact between us that we're going to have certain ethical standards in how we make these t-shirts. We're not going to have 5-year-olds running sweatshops. We're not going to have we're not going to test dye on animals, on bunny rabbits in the back room, or whatever ethical codes you can imagine might be associated with the colors or the distribution materials. We're not going to have slaves picking the cotton to make the t-shirts. Whatever regulations you can imagine. So we get together and we say, okay, we're going to have this ethical code. And because we have this ethical code and we stand by this ethical code, we don't need government oversight because we have this ethical code so what's the purpose of having government oversight if we're already doing what the government would want us to normally do? If the people in the hierarchy are dedicated to this course and aren't trying to find ways to just use this to manipulate people, it's a principle of work. It really is. It can, in theory, but in practice, completely different idea. In practice, it permits a unified invasion into all levels of government by trained and well organized individuals, essentially an outside cabal of influence. As I've mentioned in previous videos, they have managed to change the laws in this country to where you have to be a lawyer to be a judge. Prior to 1878, that wasn't even a concept. Businessmen were judges. Landowners were judges. You didn't have to have an understanding. The idea was the attorney would come to you, explain to the judge what the law is. The person, whoever the judge was, whatever their background was, would take the information that was given to them. They would assess it, they would understand it, and then they would make a decision on it. It didn't require a law background, didn't require an understanding of how the law worked, because the attorney's job was to explain to the judge what laws were applicable. And then it was up to the judge, the magistrate, or whoever to make those decisions, and it did not require a pre-existing background in law. In fact, 99% of the judges who are on the bench across the country do not know every aspect of law and have to research new laws when it is brought up to them in court. So having a pre-existing understanding of law as a concept does not in and of itself mean that you have an understanding of all law. The United States Supreme Court justices, if you could, I guarantee you, if you met any of them on the street, any of them, just name one, walk up on the street, choose 10 esoteric concepts of law and ask them about case law that relates to that and what the precedent is on them. They might get half of them. For the other half, they'd have to go back and research because they don't know all of this. No human can. Law is an expansive subject that unless you have an eidetic memory and a massive commitment to understanding and reading every letter of every book that's ever been written on the subject of law, you're not going to know everything. So having a pre-existing aspect of law to be an attorney, or for that matter to be a judge, is irrelevant. So long as you know enough about how the law works, you can research it and you can find out. This is my background, ladies and gentlemen. I don't have a law degree. I have no experience other than largely being self-taught. Largely. I've worked with some attorneys' offices. I've worked with attorneys, individual attorneys. I've even sat down and had a discussion with a judge or two in my years. It doesn't matter. I don't have an attorney's license, therefore I can never be a judge. I could never be, and now because of this felony they've put over me, I could never be a judge. I could never be a judge because in order to be a judge, I have to be admitted to the State Bar of Montana, and the State Bar has to approve it, and the State Bar is never going to approve me to be an attorney, ever. Now, maybe if I move to another state, different story. So let me amend that. I will never be a judge in Montana, okay? If I can manage to get past this next 2.5 years without them finding a way to send me back to prison for 15 more years, or come up with a new crime entirely that never existed, but hey, they sent me to prison on a made-up story before, so why not now? But the idea here is that so long as you have an organization that can create a unified influence over law, it's an Illuminati concept. It's world government concept. It's the idea that you have a secret organization operating under the pretense of law, governing and controlling governing. As I mentioned before, these attorneys, they are the judicial branch. They are judges. You cannot be a judge and not be an attorney. Organized affiliation there, everybody. Again, this is not to say the ABA, the American Bar Association, is by itself corrupt. But it permits corruption to exist through its own complicity and its own structure. There is no mandatory requirement to adhere to ethical codes. If you remember the American Bar Association, the worst they can do is fine you or kick you out. There's nothing they can do to force you to do it. I can rob, cheat, steal, whatever. Be a member of the American Bar Association. Somebody complains, they censor me, Okay, congratulations, I got a censor on me. It doesn't stop me from doing it. Doesn't take away my law license. Doesn't take my law degree away. I'm still licensed in the state where I'm practicing. That law license is all that matters. American Bar Association kicks me out. Big deal. Big deal. They're not a government agency. They have no oversight over me, other than the fact if I pay them dues, they have the right to oversee me. If I choose to withdraw voluntarily or I get kicked out, it doesn't stop me from being an attorney. Assuming I can be an attorney. Again, this is all hypothetical because I can't be an attorney in Montana. But it can only have a limited influence over their members. So, although they're saying we're going to self regulate ourselves, and we're going to make sure that we have these standards that come up through the law schools, and we're going to pass these model codes of ethics that we are suggesting that the states adopt. There's nothing that actually requires the states to adopt them, state bar associations or the state legislatures for that matter. They're just a model. Follow our model, follow our example. That's it. Please, by the gentility of your soul. Then we get down to the Montana State Bar Association. And that's quite a bit different than the much larger beast. Initially in Montana, it was called the Montana Bar Association. It was a voluntary organization. There was no mandatory compulsive element to it. Basically what it was established in 1885, 2 years after the formation of the American Bar Association. So, sorry, my bad. 1878, 1885. So 7 years, 7 years after the formation of the American Bar Association, the voluntary Montana Bar Association was formed. Again, voluntary, much like the ABA, voluntary. No mandatory requirements. In 1972, the Montana created a new constitution. And in that new constitution, it gave legislative power to the Supreme Court. It said that the Montana Supreme Court could now regulate the admissions to the bar. Now, keep in mind, at that time, the bar was a voluntary organization, which means the constitutional change gave the Montana Supreme Court the ability to determine whether a voluntary organization, whether the standards of admission could be allowed. No government affiliation, no anything. It said, okay, we get to control your membership because the Constitution says so. It put a stranglehold on the Montana Bar Association. It brought them to their knees. The Montana Supreme Court now controlled who could and could not be part of this voluntary organization. Surprise, surprise. 2 years later, here comes Montana Supreme Court with their own order, creating their own version of it, called the State Bar of Montana. And now the state, and this is really an important aspect. Nothing in the Constitution says that the Supreme Court can create or order created a bar association. The Constitution says the bar exists at the time the 1972 Constitution was signed. The bar was a volunteer organization, and it gave the Supreme Court the ability to control admissions to the bar. That's a really important distinction, ladies and gentlemen. The Montana Supreme Court took it upon themselves, when their own invasiveness created an aspect where the voluntary organization could no longer exist. They ordered the creation of their own version of the bar. Nothing in the Constitution gave them that power. Nothing. This actually still required an act of legislature. A legislature could create a Montana Bar Association and make it subject to the Supreme Court. Supreme Court has no legislative power. It's legislation from the bench. It has no legislative power. Montana, because the Montana Constitution gave them the ability to control the admissions to the bar, they took it upon themselves to create, or order created. That's important. They didn't create it. They ordered it created. It's an important distinction here. Because even though technically the State Bar of Montana was created by the Montana Supreme Court, or at the order of the Montana Supreme Court, it is not technically subservient to the Montana Supreme Court. They are an independent agency. They have their own board of trustees. They're self-elected from their own memberships. They collect dues to pay for themselves. They're not supported by the taxes of the state. There's not part of any kind of funding or anything else. They're completely supported by dues and by fundraising. That's it. They're basically a nonprofit that exists under the protection of the Montana Supreme Court. And once again, ladies and gentlemen, remember the fox and the henhouse example. The Montana Supreme Court are attorneys. The judges of the Montana Supreme Court are attorneys. You have to be an attorney to be a judge. Judges are attorneys, attorneys are judges. That's the way it is. You just basically said these 7 people get to control the who is and who is not an attorney. They basically put themselves in a position of control and influence over what is supposed to be an independent, ethical organization. And the corrupt government of Montana seized it through the constitutional change in 1972 to give them control and power over admissions to the bar, and thereby usurped the bar itself under their control and influence. Now, as I said, they're self-regulatory. They have their own board of trustees. They're completely self-elected. There's no member of the Supreme Court that sits on the board unless they become an elected member themselves. And it's up to the bar itself to decide. They are not a government agency. They exist because the Montana Supreme Court ordered them to be formed and organized, and ordered that all attorneys in the state must attain admissions through this bar in order to practice law in the state of Montana. But they are not themselves a government agency. It would be like the Montana Supreme Court coming around and saying, okay, you know what, I want to make a car company. So we're going to order this car company to be made, and we get to decide how many cars and to whom they can be sold. How does the Montana Supreme Court have that power? It does not. Nor does it have the power to actually create the Montana Bar or the State Bar of Montana. Nothing in the Constitution gives them that power, just the admissions part. And by the way, the Constitution only says the bar. And I find that incredibly convenient that in 1972, they don't say controls admissions to the Montana Bar Association. It says to the bar. Unnamed. I honestly cannot imagine that with a 2-year separation between the act of the adoption of the Constitution and the ordered creation of the State Bar of Montana by the Montana Supreme Court, that there was not a collaborative intent and purpose all along. If you don't name the bar, and you just call it the bar, then there has to be something involved there. There has to be a reason you didn't name the Montana Bar Association. Because it could be the bar of anything. It's understood as the bar. It's understood as the Bar Association of Attorneys. But literally the language of it could be the bar of anything. It could be the bar down the street. The Supreme Court now has control of who can enter and exit the bar. I mean, come on. But we're talking about the Great Montana Conspiracy here. So we're not talking about things that necessarily happen independently of each other. We're talking about things that happen in a sequence, in a chain of sequences that are planned and petitioned and controlled through mechanisms that are going on that you're not even watching, you're not even looking at. Because, I mean, what state constitution they ratify their constitution to add a power to give admissions power to the Supreme Court? Montana. So basically what I'm saying here is that in Montana, corruption goes hand in hand with government. I think I've demonstrated that pretty effectively. So when you have a self-regulation that is forever sheltered from external rules, it's corrupt to the core. The legislature is the only branch of government that has the power to make laws. That's it. Legislative branch. Executive branch can't do it. The judicial branch can't do it. But they changed the Constitution to give legislative power to the Supreme Court. And technically, they didn't actually give it through the Constitution. Just the Supreme Court simply usurped the power based upon the fact that they had the power to grant control admissions. So when you give the state Supreme Court power, you're completely removing any kind of checks and balances. Because in order to have checks and balances, you have to have power over the other branches. The legislative branch has to have power over the judiciary. The judiciary has to have power over the executive. The executive has to have power over both. That's how checks and balances work, ladies and gentlemen. The three branches of government are supposed to be co-equal. They're supposed to work against each other so that they balance each other out. But in this one move, the judiciary took complete and total control of who can and cannot be an attorney, and therefore who can and cannot be members of their own branch of government. Does anyone else see a problem with this? Well, if you don't, then you're probably an attorney and you like the way the system is set up in Montana because, hey, free reign, ladies and gentlemen. You can do whatever you want. So long as you make the powers that be happy, you can do whatever you want. You don't have to be honest. You don't have to send it to the ethics. You don't have to even take an oath of office. Even though an attorney is considered an officer of the court, you don't really have to take an oath of office. All you have to do is pass the state bar and get admission to the Bar Association. Oh, and have a law degree. So it's not that hard, ladies and gentlemen. I mean, don't get me wrong. Yes, passing a bar is hard. It's not an easy thing to do. It requires a lot of study. It requires a lot of application. It requires you to actually know the law and the histories of the law that they really want you to go into. But much like an IQ test, so long as you know what those and have the expectations of what the previous state bars exams have been, you have a pretty good idea what they are, can plan for them, prepare for them, have a pretty good understanding going into the test, and be able to pass it. And once you've passed the test, you have your bar association so long as you pay your dues every year. Yeah, you're supposed to go into, in theory, put in a certain number of retraining every year so you can keep up with the current laws and everything else. But honestly, I've never seen anybody sanctioned for not doing it. So yeah, it is what it is. The Montana Supreme Court just took all their buddies and put them under their umbrella and said, okay, you guys can do whatever you want because we're now in charge. Don't worry about it. We're the foxes. You guys are foxes. We're all equal. Yeah, I'm in a position of higher power and authority, sure. But we're still all foxes. I'm not going to give the chickens any more power over you. Of course not. Why would I give a chicken power over you? You're a fox, I'm a fox. We're foxes. And that's how the judges see the attorneys. You can't have the judges controlling who's an attorney. You have to have another branch. You have to have somebody else do it. Even if it's an independent agency. Even if it's a legislatively controlled independent agency that controls it and oversees it. Because as it exists right now, the Supreme Court controls its own members. The Supreme Court, who are clearly in conflict of interest, get to tell other attorneys who can and cannot be. And you got to make them happy because otherwise, they could come in and control your admission to the bar. So now you understand. This is a much more integral part into the Great Montana Conspiracy than what I previously said in my last video. But at any rate, always, if you have any questions, by all means send them to me. I'm obviously willing to comment and explain myself even further. If you have any suggestions, any information, by all means send it to us. If you wish to support our program, please look at the information that's attached to this video. If there's information that's not attached to this video, by all means, please go to monspiracy.podbean.com, which is where this podcast originates. Or even better, go to YouTube. Look for the Great Montana Conspiracy Podcast, like and subscribe. Thank you for your time. I hope everyone can be safe. And as always, whenever possible, please be free. Thank you.